Welcome everyone, and thanks for joining. My name's Holly Jameson. I'm a senior competition expert at the OECD. I'm grateful for the invitation to be moderating this webinar on enforcement cooperation in unilateral conduct cases. We have great speakers from across the world, all with extensive experience. We have with us Andrew Heimert, Counsel for Asian Competition Affairs at the U.S. Federal Trade Commission, Rachel Brandenberger, the CMA's NGA. Rachel is also a former special advisor, international, to the U.S. Department of Justice's Antitrust Division. Michele Pacillo, International Affairs Officer at the Italian AGCM, and Satoshi Yoshida, Deputy Director of the Office of Policy Planning and Research for Digital Markets at the Japan Fair Trade Commission. Also supporting us with the question period are Juliana Galbiati and Jerome Schall from the Autorité de la Concurrence. First, a disclaimer before we begin. All our speakers are speaking in their personal capacities. They do not necessarily represent the views of their agencies or their former agencies. We'll be recording this discussion, and it will be available on the ICN website for future use. So this session is thanks to the ICN Unilateral Conduct Working Group and France, its co-chair. The ICN and the OECD have done a lot of excellent work on international cooperation. During the next hour and 15 minutes, we'll pick up on the work done in their joint report and talk through how cooperation takes place through the life cycle of a hypothetical, multi-jurisdictional unilateral conduct case, and learn from cases in key sectors, including digital and pharmaceuticals. With over 140 authorities around the world enforcing competition laws, and many investigating the conduct of dominant firms in the tech and other key sectors, this is an important conversation. Enforcers are facing more cross-border competition violations, more overlapping cases, and more possibilities of diverging outcomes. We'll hear how agencies working together helps with these challenges, and how enforcers are getting by with a little help from their friends. On that, in a recent speech, Executive VP Vestager highlighted the importance of cooperation in today's digital abuse of dominance cases, in particular in the ad tech sector. She applauded the power of cooperation in Europe's ECN and cooperation with other partners beyond the network, like the US and others, to tackle cases with a worldwide dimension. Our experts are going to cover 4 questions that will take us through the phases of an investigation, from detection of parallel cases to investigative cooperation, to coordination of remedies and decisions. Then we'll talk through some challenges of cooperating, how to get over those, and some new tools to keep pace. We'll save 10 minutes at the end for your questions. So if you have questions, please put them in the chat as we go. So with that, we'll get started. Starting at the beginning of a case with detection. Andrew, can you tell us how the FTC learns about parallel unilateral conduct cases being investigated in other jurisdictions?
Sure, happy to do that, Holly, and I'll start by thanking you and the ICN Unilateral Conduct Working Group co-chairs for arranging this panel discussion. I know we were supposed to have it a year and a half ago, but we stuck with it, and glad to be back here today and I'll extend the thanks on behalf of all the panelists, so we don't have to repeat that. But I think, look, we probably, like a lot of jurisdictions, learn of investigations that may be similar or parallel to one of ours from a variety of sources. The easiest is, of course, when another agency calls us and says, do we have an investigation open into a particular company, set of companies, or form of contact? I mean, this is sort of direct contacts with our counterparts through the networks we've built through various mechanisms, ICN being an important one. We also benefit from the practice in a number of other jurisdictions, which is not one that we have in the US, of revealing investigations at a relatively early stage. It may come out in the news. It may be part of the process to announce it. Another way we learn of investigations is through the third parties or complainants, right? They may come to us with concerns about a company's conduct, and they may be going to other enforcers elsewhere in the world as well. And they'll tell us when they come to us and lay out what the concerns are, that they've also spoken, say, to DG Comp or the CMA or the JFTC. And that gives us an opportunity to then go contact that agency. And finally, I'll give a plug for news services. I think in the last 10 years, various news services have become much more robust in their reporting, whether they're non-public sources or more public sources. It's hard for us to keep track of what's going on around the world without them. So, the FTC has subscriptions to these. We can see every day, whether it's MLEX or PAR or Global Competition Review, just to name a few, that will report on an investigation or something overseas. And that gives us a basis to say, oh, maybe we should contact someone else if we have something similar that we're looking at.
Thanks, Andrew. That's helpful. If we could go to Satoshi for your advice for learning about similar cases based on your experience at the JFTC. We can't hear you, Sat.
Sorry about that. I'm muted. First of all, thank you so much for giving us this great opportunity. So the information on overseas cases can be triggers for international cooperation. And the JFTC has lots of opportunities to learn what other authorities are doing and whether parallel or similar cases are existing. For example, JFTC finds that overseas authorities are investigating similar cases through notifications based on the legal frameworks such as anti-monopoly cooperation agreements, economic partnership agreements or EPAs, memorandum of cooperation or MOCs, or the OECD recommendation, or also multilateral cooperation frameworks such as ICN or OECD. Especially in the digital field, firms' conducts which overseas authorities find problematic are also likely to be made in Japan. So JFTC has been paying much attention to other authorities' enforcement activities and always checking widely their press releases and media sources on such field. Plus, JFTC also obtains information about overseas enforcement activities from concerned parties or collaborators on our cases, though this does not apply in every case. Thank you.
Thank you. And Michele, in Italy, is there a different approach when we're working with the ECN, the regional network for cooperation for European competition authorities?
Hi, Ollie. Hello to everyone. I'd like to thank the co-chairs for this opportunity, first of all. Secondly, yes, within the ECN, the European Competition Network, we have a system of informing each other about new cases, conducting cases that require the application of Article 1 or 2 of the treaty, that is the provision on abuse of dominant position, when there's a cross-border effects and impact on the interstate trade. So there is a duty to inform the network every time an agency is about to launch an investigation, applying Article 1 or 2, and the notification of this new case opens a 2-month period in which the network can decide the allocation of the case, potential reallocation of the case, because as you know, the ECN's framework is based on a system, flexible system of work sharing of parallel competencies in applying the European Union competition rules by all the national competition authorities, and is also based on the principle of the well-placed agency. So in order to make this principle work, it's very important to ensure that communication about new cases are transmitted to the network and dealt with in network. We have a dedicated IT infrastructure to make sure that these communications are secure and safe. Thank you. And as I said, this is important for the case allocation at the very beginning, because other agencies might express interest in dealing with the same case or already investigating a similar case. So this allows internal discussion on who's the best placed agency. There are some criteria, depending on whether the evidence is or whether who are the best agencies in terminating the infringements or in executing the decision and so on. And agencies also who are interested in such case can also suspend their own proceedings or close their proceedings and inform the parties that another agency is dealing with the case. So this is flexible system. Thank you.
That's interesting. Thanks very much. Those are all helpful agency practices. Now we can turn to Rachel for your perspective on this. Do businesses actively inform agencies of parallel cases or encourage them to interact with counterparts?
Oh, well, thank you, Holly, and thank you so much to the French Autorité and everybody who's been involved in putting this webinar together. I'm going to give you a typical lawyer's answer. It depends. And why I say that is because, as I'm sure this discussion is going to reveal, it isn't one size fits all, either from the agency's point of view or from the company's point of view, in terms of unilateral conduct and cooperation between agencies and jurisdictions around the world. And that's for a number of reasons. As we all know, that the laws differ in different jurisdictions, the procedures differ. We're going to come on and I think discuss this in a bit more detail. The remedies differ. Also, from a practical point of view, there is, unlike in the mergers context, where a filing triggers a process, or in the cartel process, a dawn raid often triggers a process. There's no trigger point necessarily in relation to unilateral conduct investigations. And also, many jurisdictions don't have specific timelines for unilateral conduct investigations, and they vary not only to jurisdiction, but also from one case to another within a jurisdiction. And there are significant differences in the underlying laws across the Atlantic, for example. And from another practical point of view, businesses don't necessarily know that they are being investigated, certainly not at an early stage. Before matters get formal, they may have no idea that there's actually an open investigation going on in relation to their alleged unlawful and unilateral conduct or abuse of dominance position. And finally, and Andrew sort of touched briefly on this point, there are one set of incentives if you're a defendant, which may be do not facilitate or do not facilitate at the outset of an investigation. Your incentives may change during the investigation, but there's a whole other set of incentives if you're a complainant, where you actually may want to try to do what you can to get the agencies to work together. So there's a lot in the mix to try and answer your question.
Thanks very much, Rachel. That's really helpful. So let's continue along our timeline of our case and talk about the process of cooperation. Once you've identified the agencies you plan to cooperate with, Michele, you have an interesting vantage point because of the ECN. Can you tell us how the Italian Competition Authority carries out its case coordination both within the ECN and outside of it?
Yes, thank you, Holly. Yeah, we have seen an increase in the last 5-10 years of opportunities for international cooperation, both in terms of investigative assistance that we ask other agencies to do on our behalf or we receive from other agencies, but also in terms of parallel proceedings, parallel investigations. I would like here just to mention a recent case closed last year in the pharma sector concerning, there is a Lydian case concerning a pharma group. This is a very interesting case because of parallel investigations within and also outside the network, if you want. Here, we learn about the potential, the alleged abusive conduct from the news and from the international Italian news, talking about complaints lodged to the Dutch Competition Authority. So we interact with our Dutch and complaining any conduct affecting also the Italian market, not only just the Dutch market. So we got in touch with our colleagues in ACM, and thanks to the provision under the Regulation 1/2003, Article 12, we were able to exchange, to ask them for a confidential information in order to build up our preliminary assessment of the case. And after that, we decided also to launch an investigation, concerning the geographic market of Italy, our own territory. And of course, we did notify the network of that. And this case also is interesting because we decided to carry out inspections and the premises of the relevant companies of interest for our case were located in Germany and UK. So we had to liaise with our counterparts in those two countries. And again, thanks to the framework of ECN, we were able to receive investigative assistance from these two agencies. And in the meantime, we continue to investigate the case in close cooperation, with our Dutch colleague and subsequently also with our Spanish colleague, each dealing with the same conduct but distinct geographic markets, also due to different, regulation of the pharmaceutical sector and so on. And we had several joint calls with our colleagues within ECN to exchange views also on market definition, establishing the dominance as a requirement for applying Article 102, discussion about the methodology to calculate the excessive pricing because this was the allegation, discussion about the duration of the conduct. Of course, all this interaction meant that we had to extend our timetable several times during the proceedings. Here, just a note that in Italy, when we launch an investigation, an antitrust investigation, we typically also include a deadline for closing the proceedings, 1 year usually, also to give certainty to companies, but we had to extend a few times this deadline also because of this cooperation. As I said, this case is also interesting because we cooperated, we received requests for cooperation from a non-EU agencies, in particular Israel, and we had, of course, our discussion with Israel were limited to only public information, and we couldn't, of course, share documents in the case file, but I think they found very useful to discuss with us, this type of abuse, because we have a certain experience in this area, but also we help them to point out which were the relevant public documents and explain to them, the relevant EU regulation, and also at the end, we provide our final decision also translated in English to them when it was made public, and I think it was also very helpful because it contained a lot of evidence. So this is just to show how this case raised, is an interesting example of cooperation within the network, where we have lots of powers and instruments to really cooperate more closely, and as well some non-EU cooperation limited to public information, but it was, I think, still very useful for our colleagues in Israel. Thank you.
Thank you. It's interesting to see the deeper cooperation at the regional level. Andrew, can you tell us about cooperation at the FTC and how it might differ from the EU?
Sure. Well, we don't have the advantage of a broad cooperation agreement like the European Competition Network that allows some of those robust tools. But I'll come back later to a little bit of what we're developing in that area. But I think we still have ample tools, maybe some of the more traditional ones that a larger number of agencies have, to engage in much the same type of cooperation with counterparts when we have open parallel investigation. So ultimately, I think the cooperation is not much different, although without the formal assistance of other authorities that Michaela mentioned. Our typical cooperation involves discussions of such issues as investigational status, where our areas of concern lie, such as relevant markets, and particular theories of harm, whether it's exclusive dealing or loyalty rebates, whatever it might be. And then, how those facts combined with the practices of the company may violate U.S. law, and obviously our counterparts discuss how it may violate their relevant authorities. As we get to later stages of the investigation, and I think we'll turn to this in a bit, we can discuss possible remedies that we're considering. One of the challenges that we face is our ability to share confidential business information. So we can speak in broader terms, such as what we're hearing generally from third parties, but we can't discuss specific information we've received from the parties themselves. So detailed information, say, about the types of agreements they might have with third parties that might give rise to a concern. And unlike the merger context, the parties under investigation tend to be less willing to provide waivers. So most mergers, parties are willing to provide waivers. They see it as in their interest as helping to move the investigation forward. And as Rachel suggested in her opening, parties have a different set of incentives in most cases. So it's not that they don't, but it's less common. Third parties may more frequently provide waivers, though. Again, a somewhat different set of incentives. Third parties who believe that they're being harmed by the conduct do have an interest in facilitating investigations by us and other authorities. And you would ask me to highlight, maybe a typical case, or perhaps it's an atypical case, but a useful one to highlight. So a few years ago, the FTC was investigating Qualcomm for some of its licensing practices with respect to wireless modem chips and standard essential patents. Both DG Comp and the Korea FTC had investigations into similar conduct, though at different stages of their investigation. Ours, given the nature of our system, I think was a little bit slower. We have not only our preliminary investigation, our in-depth investigation, then we ultimately have to go to court. So DG Comp, KFTC were ahead of us in where we were, at least in terms of sort of stages of the investigation and where we had to get to. But nonetheless, we were able to discuss our respective theories with these other agencies. And I did a little bit more with our cooperation with the KFTC. And I think, they were getting to a decision point. I think they benefited greatly from learning from us where we were, and that we were seeing or had similar concerns, right? It sort of, if you will, it validated the concerns that they had, and ultimately the conclusions they reached aligned with the theories we pursued in court. Now, I know ultimately while we won at the district court, we lost on appeal, but the theories we presented aligned with the KFTC and vice versa. So, and I think also the opportunity to understand the remedies that the KFTC was considering and then ultimately imposed put us in a better position to evaluate what remedies we might need to seek, whether by the companies offering commitments or as it turned out, what we had sought in court by way of remedy there. So I'll stop there and we'll talk about more of this a little bit later.
Thanks, Andrew. It looks like while there are challenges, there's still lots that can be achieved from cooperation. If I could turn to Satoshi, can you build on what you've heard and tell us the JFTC's approach to cooperation?
Sure. At first, I'd like to touch on the background of growing importance of international cooperation in unilateral conduct cases. Previously, international cooperation has been actively carried out in cartel or merger cases. I assume this is because the concerned parties in these cases would often file leniency applications or merger notifications to multiple authorities, and phases of each authority's case procedure would often be in parallel. But such circumstances generally cannot be applied to unilateral conduct cases. So the chances and the scope of international cooperation in such cases were relatively limited. However, with recent digitalization, firms like big techs are operating their business beyond the border, and their conducts are increasingly affecting competition in many jurisdictions, and the impact of such conducts on the competition of each jurisdiction is also increasing. As a result, each authority has now common problems and concerns, and international cooperation on unilateral conduct has been more immaterial than ever. Then moving to the main topic, the FTC cooperates with other authorities in unilateral conduct investigations, which centers on the exchanges of publicized information, informal information, and opinions based on stipulations in Japanese Anti-Monopoly Act and legal frameworks such as anti-monopoly cooperation agreements, EPAs, and MOCs, as I mentioned before. Such cooperation would be beneficial for some of our investigation cases, typically those in digital field. Although we cannot disclose the name of such cases and the counterpart authorities, but we have been proactively contacting other authorities and exchanging information with them when we assess it effective. In the same way, overseas authorities sometimes ask us exchange information. Information exchanged may vary from that on logistic aspects such as status or agenda of investigation to that on substance aspects such as market definition, theories of harm, and remedies. Exchanging information of these details is extremely beneficial because, especially in the digital field, evaluating substitutability of services for market definition can be difficult, or theories of harm may differ from those in traditional cases. Plus, in the case the platform's self-preferencing in several jurisdictions is suspected, like the hypothetical case Holly mentioned, we may exchange ideas on the methodology of what kind of data to be analyzed and how to analyze that in order to prove its self-preferencing. Though sharing confidential information is restricted to some extent due to domestic laws in each jurisdiction and general difficulties to obtain waivers from concerned parties in unilateral conduct cases. But so far, we understand that just exchanging public information or non-public agency information not affected by these restrictions is still very useful. To start such international cooperation, we sometimes cannot find contact windows of the counterpart authority. In such case, contact lists provided by multilateral forums such as ICN or OECD are practically beneficial. Plus, JFTC conducts market studies as part of its advocacy activities, and through such studies and remarks exchange on them, where overseas authorities may suggest us status of the market and potential competition issues, as well as overseas colleagues' concern on such market. JFTC recently hired digital analysts with referring to other authorities' practices and advices, and now they strongly support us for better understanding of digital technology and other authorities' activities in digital field, which further promotes communication and cooperation with other authorities. As such, we are taking this kind of comprehensive approach to collect information through international cooperation, which is truly beneficial for JFTC. Thank you.
Thank you. That's useful to hear that the JFTC is benefiting so much from informal cooperation and the use of digital experts in unilateral cases. Let's move on to our next topic. Let's talk about coordinated investigations more, but look in particular at issues to consider at the decision and remedies stage. One issue that often comes up is about decisions or remedies being aligned, or at least not contradictory. Rachel, what can you tell us on this and on cooperation regarding remedies and decisions? Can you share insights from the Apple eBooks case? Must decisions and remedies be aligned?
Thank you, Holly. That's a great set of questions. And the Apple eBooks investigation, I think, offers an interesting and somewhat groundbreaking example of how cooperation can work in those circumstances. It's a case that's just over 10 years old, but I think still very relevant in terms of how the cooperation was done. And I should disclose that I was heavily involved in that case when I was Special Advisor on International Matters to the US Department of Justice. But everything I'm about to talk about is publicly available information. So the investigations involved close cooperation between the US Department of Justice's Antitrust Division and the European Commission throughout the processes. There were other enforcer players involved as well. Two US states, Texas and Connecticut, were also investigating these practices and worked closely with DOJ and others throughout the investigations. And on the European side, some member states were looking at the situation until the European Commission took jurisdiction over the entire matter under the ECN mechanisms that Michaela was talking about earlier. And on top of that, in the US, outcomes of cases, whether they're involving settlements, which it happened with some of the parties in this case, or litigation, which happened with some of the parties in this case, the courts were also involved. So this isn't just agency to agency. As I expect everybody knows, the investigations involved what were then the 5 largest book publishers in the world: Hachette, HarperCollins, Macmillan, Penguin Group, and Simon & Schuster, as well as Apple. It's all about ebooks. The theories of harm were not identical, the two sides of the Atlantic. Nevertheless, close cooperation throughout. The DOJ alleged that the parties, and I quote, conspired to end ebook retailers such as Amazon and Barnes & Noble their freedom to compete on price, take control of pricing from ebook retailers, and substantially increased the prices that consumers pay for ebooks, and that this resulted in consumers paying millions, I'm quoting, of dollars more for their ebooks. The European Commission's focus was on the vertical aspects of these arrangements, and in particular on the parties' switch from a wholesale model, where the retailer determined the retail price, to an agency model, where the publisher determined the price. These are not concepts that really play in the US antitrust law sphere, although the end results were equally troubling to both agencies. So a marker down, different theories of harm, but close cooperation. In terms of outcomes, both DOJ and EC required the publishers to do a number of things, but this included terminating their agreements with Apple, not entering into new agreements that constrained retailers' ability to offer discounts and so on, and not to agree to any kind of MFN that could undermine the effectiveness of the settlement. The DOJ also imposed what it called a strong antitrust compliance program. There wasn't an equivalent of that on the other side of the Atlantic settlement. DOJ and European Commission had never cooperated on this sort of case before. So we had to work out how to do this, given that the timelines and the procedures for settling conduct cases differ transatlantically. And as I've already said, they also include the courts in the US and in the EU. For those that are familiar with the EU process, this was a settlement under Article 9 of the regulation. So this involved the two agencies, officials and case teams, having very frequent and open discussions over a lengthy period of time, both by phone, videocon, small phone in those days, and in person, about how to get this to work in terms of the very different procedures. And in fact, in one case, we literally sat down together, I and the case team and the European Commission case team, and we started drawing timelines to see our respective timelines, to see where we could align, whether we could align key milestones. Another important point, much of the cooperation in this case was done without waivers from the parties. And yet there was very close cooperation on substance as well as on procedures. And that was because there was a lot of publicly available information on the parties' websites, on industry publications' websites. And I remember going to sit with the DOJ case team ahead of a call we were scheduled to have with the European Commission case team, and literally seeing them finding relevant information on websites. So message to companies, be careful what you put on your websites. Message to agencies, there's often a lot of very useful publicly available information. However, as I indicated in my opening remarks, the party's original stance of no way are we going to give you waivers in this case can change as investigations move on and as parties' perceptions of what is the likely outcome is going to be can change. And in this case, when there came a stage when the parties realized that there was very close cooperation going on between the EU and the DOJ, and that nobody was going to get a free pass out of this case, and that there would be remedies or litigation if they didn't settle in the US. And the parties changed their stance, and both the DOJ and the EC received waivers because the parties realized that they would prefer to have consistent outcomes and consistent settlements, which they very much were, the settlements, both sides of the Atlantic. So my final point here, and I hope this sort of illustrates what we're discussing today. For those that are very alert, you may have realized that actually this was not a unilateral conduct. Of course, everybody is very alert on this webinar, but this was actually not a unilateral conduct case. This was actually an Article 101 or Section 1 case. But I think that the roadmap that case worked out is equally applicable in the unilateral conduct space. And I think, in fact, we've seen it playing out in the new Google case that you, Holly, referred to at the start of your opening remarks. So let me leave that there.
Thanks, Rachel. That's an interesting example of navigating the differences and the importance of public information. Now turning the tables to Andrew. Often when investigating parallel cases, agencies are looking at similar facts and analysis. Do you think it's important to ensure that decisions and remedies are not contradictory? How does the FTC go about this? And is it desirable for one agency to take the lead?
Sure. And I'll just note on Rachel's last point. I mean, I think that it's this sort of an ICN way of approaching things. That we have this unilateral conduct working group, but it really, a lot of these principles are effectively any non-merger civil types of cases, right? Or non-merger, non-cartel types of cases that present much the same issues. I mean, if you're looking at a vertical arrangement under Article 101, Section 1 of the Sherman Act in the United States, or your equivalent agreements legislation where it's not a cartel agreement, really the same principles apply, even though we focus on unilateral conduct in this group. But Holly, turning back to your question, I mean, it's important for agencies to try to reach consistent results and avoid inconsistent obligations through remedies or just determinations of law. And I think we're not doing that just for the sort of the sake of consistency, right? It's not consistency for consistency's sake, but rather that consistency reflects the fact that we are taking a common sound approach, even if maybe you get there through a different legal channel, as Rachel was illustrating. The results were pretty similar. And agreeing on the facts, the theories of harm can help greatly in reducing the likelihood of these inconsistencies. Even if again the legal framework is a little different, the theory of how the harm is affecting competition is something one can agree with, and by collaborating and talking it through. I mean, obviously, consistent results can be a challenge when there are different laws and facts. Rachel gave the counterexample, but for example, market position may be very, very different in different countries. I mean, any number of industries, this is true. I mean, you look at something like mobile phones, where operating systems have wider adoption between Apple and Android. Different regions adopt those at different rates, right? So that could be a relevant thing, and I don't mean to highlight just those two companies, but really that's true throughout any number of industries. I mean, arguably, if you have different facts like that, and maybe different laws, it's not necessarily a consistent outcome. If our law doesn't allow us to reach conduct, so we close an investigation, maybe that's not a strike against consistency. So I think we have to be thoughtful about saying, well, we don't have to always be consistent, because maybe consistency would reflect misapplication of law. I think as others have suggested earlier, I mean, one of the biggest challenges we face on consistency or getting to consistent results is timing. In the merger context, they're usually merger-driven timetables that parties can address through notification sequencing. Most countries have a relatively predictable timetable for merger review. But for conduct, some agencies may complete an investigation well before others meaningfully begin. And so that makes common remedies a real challenge. One agency may be satisfied with the remedies they've settled on, whether through commitments with the party or a determination, before another has gained sufficient facts to determine whether that specific remedial approach is sufficient. Maybe it's too much, maybe it's too little. But I do think, going back to the basic point, if the agencies are pursuing the same basic theories with the same sort of set of concerns, whether through a consent or commitments, the parties can help facilitate that discussion and help to reach a consistent or even common agreement with multiple enforcers. Holly, you asked me to sort of touch on one possible mechanism, and this is, something maybe not broadly applicable, but might in some cases, which is the idea of having, maybe a lead agency with others that sort of rely on that lead agency to really drive the investigation and maybe sort of determine the outcome. And it might be the jurisdiction with sort of the greatest interest or greatest connection to the conduct when others have, it's not unimportant, but maybe of lesser importance in those other jurisdictions. And that way, whatever that lead jurisdiction does, hopefully solves it for everybody, and the other agencies don't need to go through all of the same steps. I mean, there are obviously challenges to this kind of approach, so it's not universally applicable. First, you have to make sure that you trust those other enforcers to do a good job and really represent your agency's, your country's interest. Other agencies may not have authority for the geographic scope of remedies being sufficient. I mean, DG Comp studiously adheres to limiting its remedies to the European Economic Area. Totally understandable, but those kinds of limitations may mean that in other jurisdictions the remedies have no application, and the parties may not extend that approach beyond the borders of the EC. And then finally, this is particularly important in the United States for the FTC, and I think DOJ has a similar view, is we want to be able to enforce the remedy ourselves if there are violations, right? So if we don't have an order in place, we have no legal authority to say you violated the order, you aren't meeting your obligations. So again, another limitation that may make this approach not attractive in a substantial number of cases. So I'll stop there, Holly. Just put that thought out there, but happy to carry on.
Thanks very much. It's helpful to know about the challenges of remedies that they can raise, but also there is potential to align under the right circumstances. Michele, do you have any experience to share on coordination of remedies or decisions?
Yes, Harley. First, a general point, aside even the ECN framework, I think, but it can be also useful for other agency here today, is that, for instance, in the Italian legal framework, there is no explicit committee provision, but we still think that the general international public law principles are applicable in our proceedings. This is to say that even if we don't have express provision that allows us to take into account remedies, in this case, adopted by other agencies, in third countries or in other, or even in Europe, we still trying to consider the impact of our decision on other jurisdiction, or the impact of decision taken in other jurisdiction in our own territory. So this is a general point. In terms within the European framework, in some way we have already this concept of the lead authority mentioned by Andrew. In most cases, it's the Commission is the lead supranational authority that takes charge of cases that have relevance, in more than 3 member states, or the cases that raise important issues for the competition policy, because the Commission is the ultimate responsible for the application, for the consistency of your competition policy in the European Union, and this supranational authority also, in this regional network, also has an important role in checking, in supervising the decisions of the national competition authorities, checking also the consistency when it comes to remedies. Of course, also having regard to the specific, specificities, the peculiarities of national markets. But there is this important role of checking by the Commission, checking the overall consistency of the agency's decisions within the network. We also have the opportunity within the network to have a lead agency, which is not the Commission, that takes charge of the investigation in several, affecting several member states. So this is also a possibility. Or another possibility is when an agency decides to close these proceedings because there is another agency dealing with the same case, it can ask this agency dealing with the case to take also measure to sanction also for the effects in its own territory. So there is this possibility of cooperation within remedies. In our actual practice, I think, as Andrew said, the biggest challenge is often the timing. Coordination of remedies is very easy when the timetables are quite aligned. And for instance, this was the case of the back in 2016. So booking Expedia is not an abuse case, but we cooperate a lot with France and Sweden, and also in the accepting the commitments for the entire European area. But it becomes more complicated. It requires more efforts when the investigation timetables are not aligned. But it's still possible to reach a coordination in remedies. And for instance, we have this case of coordination remedies concerning the Amazon FDA logistic case, conduct affecting the logistic for e-commerce linked to the Amazon marketplace. The Italian Competition Authority launched this investigation and carried out an investigation. At one point, the Commission also intervened under, within the framework to consider the same conduct and to open an investigation for the same conduct, but for all Europe apart from Italy, because Italy was already at fairly advanced stage of the investigation. So we had to cooperate not only, in terms of the theory of harm, of the investigation strategy and so on, but also in terms of remedies. And the remedies that the AGCM imposed at the end of its proceeding largely substantially reflect the commitments accepted later on by the Commission at the end of the last year. So this is again an example where coordination on remedies is possible, but of course it was made more difficult because of timing misalignment. Another important point, if I may, still in the remedies area, is in the Lydian case I was referring to before on the pharmaceutical sector. The authority, in setting the fine, the amount of fine, considered it important to coordinate also with the other agency, to consider the fact that the same conduct was being investigated and sanctioned by other agencies, and therefore, in order to ensure that fines are proportionate to the seriousness of infringement, decided not to apply a deterrence multiplier to the basic amount of fine. This deterrence multiplier can be applied by the authority, within its own fining guidelines, as a deterrence, to account for deterrence, and it can increase the basic amount. But in this case, the authority decided not to do, even if it considered that it was this case deserved the multiplier, just because to account for the fact that the conduct was going to be sanctioned and was already sanctioned by other agencies. Thank you.
Yeah, that case is a good lesson about how to take into account other investigations and potential remedies of others. So thanks for raising that. Now let's go deeper on the limitations of cooperating on abuse of dominance investigations and ways to get over those challenges. The ICN OECD report on cooperation pointed out that there are both practical and legal obstacles. The OECD went a step further, writing a report that looked into how enforcement cooperation is done in other areas like tax, anti-corruption, securities, and police cooperation. It looked at the successful ways that they are sharing confidential information, assisting their foreign counterparts with information gathering or legal assistance, or engaging in enhanced cooperation like joint investigation, lead agency models, or regional networks. Various instruments are used and described in that report, conventions, treaties, and MOUs. We'll put the report in the chat for you, as it's a great resource with ideas on how to overcome legal obstacles and potentially improve cooperation in competition investigations. So now I'll turn to our speakers. What do you see as the challenges to international cooperation in unilateral conduct cases? What's missing from enforcers' toolboxes? And can you see ways to address those obstacles? I'd like to start with Rachel. What are the challenges the business community faces with international cooperation of competition authorities? What cooperation is realistically possible? And what can be done in the future?
Well, thank you, Holly. And I think your stress on what is realistically possible is really important here. I mean, we've got a lot of studies and research, which is all great. We have discussions like today's discussion. We have case studies that we can, of actual examples of effective or maybe sometimes not effective cooperation that we can learn from. I mean, the more recent OECD ICN report on international cooperation is actually the second such report. The first report was done 10 years ago, but the findings in the two reports seem to be broadly similar. So I'm not sure a lot has changed since then. The first report's interesting because it's actually the first time that OECD and the ICN had cooperated themselves on a survey and then a report, or technically two reports at that stage. I think the report on the thinking out of the competition box report, if I have that title correctly, it really merits close reading by everybody. I have suspected for a long time that we could learn from people that are not doing competition law and bring ideas to the competition law space. I think it's a little, maybe it's been clear from what I've been saying. I think there's a lot of potential still to be exercised within the current setup of competition law, without necessarily needing new tools and new instruments. And maybe some of the examples that we've been discussing this morning, people can take and think about how they could apply to other cases. I mean, and it's also worth bearing in mind, and I'm not saying they're not things to be discussed, but I'm emphasizing the realistic concepts like lead agencies. Well, there are many agencies around the world that actually, under their laws, they can't stop an invest. They need to deliver a result if they open an investigation. And then there's the sort of human factor. Who would you be prepared to accept as the lead agency if it isn't you as the agency? That's just a human nature thing. And on the various proposals for second generation cooperation agreements, again, I'm not suggesting they shouldn't be thought about and that they're not appropriate, and they do indeed exist in some circumstances. But given the discussion we've been having about how parties may be reluctant to give waivers at all, how does that play if you're actually being asked by an agency with a second generation agreement to give a waiver? Because then the waiver isn't just to that agency, it's to others that that agency could share the information with. So bottom line, let's do more webinars like this and other discussions to really work out what can be done within the current context, and then articulate it to business and try and get them on board as well.
Thank you, Rachel. And Satoshi, which challenges does the JFTC experience with international cooperation?
Okay, so as the examples of practical limitations on international cooperation, I can say regulations and investigation procedures vary in each jurisdiction. Elements of the violent conduct may also vary in each jurisdiction, and obtaining waiver from concerning party is generally so hard. As a more practical challenge, I feel that many unilateral conduct cases, such as those in digital field, are opened in each jurisdiction, not at the same time, but with a slight time lag. So it is also conceivable that the number of international cooperation between authorities at different stages of the parallel cases investigation procedure could be increased. That means, for example, there may be a cooperation between an authority which officially opened the case and another authority still under preliminary investigation on the case. Some of these limitations and challenges are due to the differences of legal or social background in each country. Might be difficult to be removed uniformly all over the world. Nonetheless, just like today's webinar, it is important to continue accumulating and sharing various examples of cooperation in multilateral forums such as ICN and OECD. I believe it will enable us to share efforts to maximize the effects of international cooperation within existing frameworks and to make future challenges much clearer. Thank you.
Thank you. Yes, the ICN and OECD are working hard on that. Thanks for that helpful perspective. Turning to Andrew, can you tell us how the FTC is overcoming challenges of international cooperation, including creating new tools to promote better and deeper cooperation?
Sure. Well, I think it's not really a new tool. And we've already talked a little bit about what second generation cooperation agreements entail. And I'll give just for those in the audience who may be a little less familiar with the terminology, what we call first generation agreements are sort of the more typical, I would say, basic cooperation agreements or memoranda of understanding. At least the FTC with DOJ have currently, and I know a number of other jurisdictions have these. And they set out a basic framework for cooperation on policy, on enforcement. Ours and I think others have mutual pledges to cooperate on cases when appropriate, and then guarantee the confidentiality of the information exchanged. I mean, at least as best as possible. If we tell DG Comp something, we can rely on DG Comp not to share that publicly, and vice versa. And that's true with under all of our agreements. So second generation agreements take that a few steps further by allowing both the exchange of business confidential information without waivers and, at least in our case, and I'll turn to this in a moment, providing investigational assistance in the form of evidence gathering. And I think this is, Rachel has maybe some skepticism, if it's fair to characterize that as an approach, but I think this is a potentially big improvement, right? Waivers are always at the option of the party. And that means that the party can grant them or not grant them, and usually does grant them only when it's in its interest. She highlighted in the Apple eBooks case, parties initially didn't grant waivers, but then down the road they realized, okay, now they're better off granting waivers, so they did. So I think from an enforcement perspective, not being subject to what the parties find in their interest as the only way to exchange confidential information is an important step to take. So what are we doing at the FTC? And this is obviously with our friends at the Department of Justice. We entered into, with several other jurisdictions, something called the Multilateral Mutual Assistance and Cooperation Framework, or MMAC for short. So it's 6 countries, 6 agencies in 5 countries. So United States, United Kingdom, New Zealand, Australia, and Canada. All of them have relatively similar legal structures. We're all sort of common law jurisdictions, differing from much of the world. So it puts 2 things in place. One is a cooperation agreement for, to the extent we didn't already have them with those other countries, sort of a first generation type agreement. And then second, it sets the stage with a model second generation agreement for information sharing and investigative assistance among the group. So this model second generation agreement is designed to facilitate easier negotiation bilaterally, because for each of these countries, we have somewhat different laws, and we have to account for the legal differences among our authorities for sharing information. We have a particular law with limitations, all of the others do as well. So the determination was it would be better to negotiate bilaterally these sort of second generation agreements as those authorities are put in place, modified, and so forth. But the broader goal is that this model could ultimately become a basis for additional agreements outside the MMAC group. I mean, that's where we started, but there's no necessary limitation to it, and it's certainly, without revealing too much, we certainly have an interest in these types of second generation agreements with enforcers outside of this group, and in fact have had those discussions with some other agencies. I would say, these types of agreements are not without their challenges, like everything in this area, right? First, you need specific legislation, and that can mean there's some misalignment on laws on that information sharing. One prominent example is the United States treats cartels as criminal, but many other jurisdictions do not treat cartels as criminal, or may just not be allowed to share information for use in criminal proceedings in the United States. So that creates one limitation. On the other side, our legislation in this area doesn't allow us to share materials from mergers that were notified under the Hart-Scott-Rodino Act, and that represents the bulk of our merger work. So from our perspective, we can do less to share with others. But let me turn more generally to what I see as the necessary tools for cooperation, really for any agency to have in place. And again, this is maybe for those agencies who are still at an earlier stage of developing their international cooperation. The first is, I think, to have this mutual guarantee of confidentiality with a counterpart agency that you're thinking of cooperating with. This can be an MOU or some agreement. It could be a letter agreement, just a one-off saying we agree that we'll keep confidential any information we exchange during case cooperation. Or maybe another mechanism, such as mutual adherence to the 2014 OECD recommendation on cooperation. All of those can be tools. It's obviously going to depend on what your agency's legislation requires, or the burdens that the obligations it imposes on you. And then the other, and I think I started this way, so I'll come towards the end of my remarks today this way, which is using networks like ICN or other regional groups to build relationships with your other agencies you may cooperate with. This facilitates outreach. It's a lot easier if you know the person you're calling, or at least you know a person that you can call and say, hey, who should we talk to? Who should our case team talk to facilitate that outreach? And it also builds trust and comfort, right? You're much more willing to share information that may be sensitive with another agency where you have a little bit longer standing relationship and know that they will hold that information in confidence and not abuse that trust. So I think building that trust through these kinds of activities that we see in ICN is a really important step. Going there.
Thanks very much. That's all useful advice, and it's positive to see tools emerging despite the challenges different regimes pose. Michele, could you just take a couple minutes to talk about some challenges that you see in Italy, and whether you have any suggestions for improving cooperation, getting over those hurdles?
Thanks, Holly. Yes, I think I tend to agree somehow with Rachel on the fact that we have to be realistic at the moment. There are several constraints on cooperation, legal constraints, and at least from our perspective in Italy, they can only be overcome through legislative changes. So that could enable us to exchange confidential information or to provide receive investigative assistance from others outside the EU I'm talking about. So I would probably think that one thing that we can work on now and we're already doing is to, through these multilateral networks, bilateral agreements, MOUs, we can strengthen the relationship, personal relationship among case handlers. And because sometimes the benefits, the importance of international cooperation is only felt at top level of the agency or by the international affairs officers of the agency, but not by case handlers who mostly perceive, at least at the beginning, the costs of cooperation. So it's important to involve them in exchanges with other case team of other agencies, and even if they can only exchange views and talk about public information, I think this is still very, very useful. And I'd like to point out that recently, for instance, we signed an MOU with ACCC, with whom we had already a very good relationship built up within ICN and OECD. But this MOU is fostering a little bit more interaction among the case teams on different areas, not only just competition law, but also consumer protection. And I think this is, we are organizing bilateral calls, and this is creating confidence. And maybe one day, if we are allowed to exchange also confidential information with the, with the ACCC or with any other agency, we establish a strong relationship. I think this will be a plus and will facilitate formal interaction. Thanks.
Thank you. And maybe I'll just quickly mention some OECD tools to support agencies with cooperation. There's the cooperation recommendation. It's a best practices document that's very useful. And in fact, you spoke about a law reform. In one section, it pushes the envelope and it urges government adherence to consider putting in place frameworks for sharing confidential information without waivers or information gateways, and frameworks for investigative assistance. So this is aimed at bridging those legal obstacles that are impeding cooperation and opening up new doors. There's also the OECD Competition Enforcement Cooperation database that has information about competition authorities' abilities to cooperate in 60 jurisdictions. And as well, there's online inventories of agency MOUs and state-to-state cooperation agreements, all on our website. And all of those resources are useful for agencies negotiating cooperation agreements and guiding them when they're looking to cooperate with a counterpart. So we'll put those in the chat for you as well. So I see we're at 3:15. If we have questions in the chat, Juliana, we have 10 minutes set aside for the audience's questions for the speakers.
Yes, thank you, Holly. So first of all, we had a positive remark from the audience on something that Andrew said on the fact that consistency may also be and result from a bad application of the law. And we have a question that I will read from Manas Shaduri. Within the confines of jurisdictional challenges between agencies across jurisdictions and common remedies being a real challenge, how does end consumer benefit finally? Is there any research on these aspects? I don't know if someone from our panelists want to share some views on this.
Julian, I'm not aware of this. To the best of my knowledge, I'm not aware of any research in this area of the effects of cooperation on the consumer side, or the negative effects of the lack of cooperation in certain cases. So I wouldn't know. I'm sorry.
Well, I could directly answer the question on the ebooks case that we were talking about earlier. On the US side, given the system in the US, as well as the settlement at federal level, the states that were involved, there ended up being a very large monetary settlement, $500 to $800 million, if I'm remembering correctly, to the benefit of consumers who had suffered from the high prices. But that's not really an answer to your question, because that all was delivered by the US system. There wasn't an equivalent, because the European system works differently in the European Commission. So I think it's a really good question. Ultimately, it's the consumers that competition law is seeking to protect, and others. And what does international cooperation, how does it help?
I'll add to that, Rachel, because I think it actually does. I mean, yes, it requires a bit of a leap of faith, but if you assume, and this is subject to question, but in that case, I think you have no question, right? If the result in one country is a good one for consumers and cooperation helps lead to similar good results in other countries, or better results than one would get to otherwise, which I think the cooperation does, then one might at least infer that consumers in those other countries have benefited as well, right? And if you have multiple enforcers taking similar results, and that's facilitated by cooperation, I think that's and that they're all benefiting their own consumers. I think if they get to a better result, probably is better for consumers. I realize it requires a couple of steps of inference there, but I think that's true of a lot of what we're doing.
Thank you, everybody.
Yes.
Sorry.
Sorry, just to pick up on what Andrew said, I think we can infer, suppose that, for instance, in our Lydian case, pharmaceutical case, where actually or even the Haspen case that we conducted a few years ago, again in cooperation with the European Commission, without with the rest of the Europe, the expected benefits for consumers were the lower prices for the drugs in question, and of course as long as the decisions are confirmed by the courts, and the exchange and the cooperation was helpful, in producing robust decisions among the cooperating agencies. So implicitly could have a positive effects on the consumer side.
So it's a sort of amplification of a particular agency's decision, is I think what we're saying.
Yeah.
Thank you all. Molly, maybe we can ask our panelists for their closing remarks.
Ollie, you've left yourself on mute.
Almost made it.
I know, I was gonna say, we made it almost through the hour and a half.
Okay, that was a great question. Yes, we're gonna finish with some very brief comments from our experts. about what would be their best advice to a case handler wanting to cooperate with a counterpart on a unilateral conduct case. So if we could do this quickly, I know we're getting to the end of our time. We'll start with Andrew, then go to Michele, then Rachel, and then Satoshi. Thank you.
So, I mean, I think I've said a lot that in the way of advice. I'll add one wrinkle or one further thing, which is, you know, if you're a case handler, use your agency's contacts with other agencies as best you can. Talk within your agency. Who knows, you know, who knows someone at the FTC if you don't in person or whatever agency it is you're looking to cooperate with. Use those personal connections to facilitate that contact that then leads to and opens up all these opportunities for more robust cooperation. You don't have to do it on your own. Use your colleagues, use their connections if you don't have them yourself.
Great, Michele.
I would simply add to what Andrew said, that, you know, ask your colleagues of the international office to be more involved in the ASEAN, Unilateral Conduct Working Group, to the ASEAN initiatives, workshops, webinars like this, and to get first-hand experience of these issues through the participation to the international organizations like this. Thank you.
Thank you. And Rachel?
First of all, I think the question is absolutely right. It focuses on the case handler. And Michele made the point earlier. The key people to international cooperation at the end of the day are the case handlers actually doing the investigations. So 4 quick points to the case handler. Think about whether cooperation is appropriate at the start of your investigation, of this particular investigation you're doing, not as a general matter. Why is it in the interest of your agency and the agency that you want to cooperate with? Because it takes time and effort. Why will it actually facilitate, improve your investigation? Waivers, we've talked about waivers. Are waivers a nice to have or a must have in your particular case? And last point, keep your strategy for cooperation under review as your investigation continues.
Great, thank you. And Satoshi?
Okay, so as I mentioned earlier, JFTC is proactively exchanging remarks and information with overseas authorities in advocacy area as well as investigation area. In this way, especially in digital field, I believe such comprehensive approach enhances the effectiveness of international cooperation in case investigation via international cooperation in other fields. It shall be really fruitful. That's all. Thank you so much again for giving me and JFTC this great opportunity to speak. Thank you.
Thanks very much. All great advice to take back to our offices. Before we close, I'll just turn back to Juliana, who has some ICN announcements for everyone.
I just wanted to recall some projects on which the Unilateral Conduct Working Group of the ICN has been working this year. So first of all, our co-chairs from the JFTC have been working on a comparative report which summarizes the results of a survey they did on analysis of theories of harm and design of remedies in digital markets. And the report is posted on the ICN website. So do not hesitate to consult it. We are, and DigiComp in particular, together with the Autorité and other agencies, are working on a paper on dominance in digital era, which focuses more particularly on market shares and barriers to entry and expansion in digital markets. So the paper is being finalized, and it should be issued in the next few weeks or months this year. Then we are also working on a practical report, on the use of urgency enforcement tools in the context of abuse of dominance proceedings. And so we will issue a survey with all the members of the Unilateral Conduct Working Group and with the aim of preparing a practical document on this type of procedural tools. Also, our colleagues from the JFTC organized a workshop in Tokyo in March, and our co-chairs from Spain a webinar on abuse of dominance in the pharmaceutical sector in February. And maybe just a word on the upcoming annual conference that will take place in Barcelona in October. Just wanted to mention again that we will have various sessions in which unilateral conduct matters will be discussed. During the plenary, we will discuss challenges around unilateral conduct cases, and then we will have 3 breakout sessions, one on how to ensure effectiveness of remedies imposed in unilateral conduct cases and obstacles encountered in case practice. A second breakout session on assessment of dominance and challenges ahead, and a third one on the interaction between antitrust and regulation in digital markets. So do not hesitate to continue to participate and be involved in the work product of the group. Thank you very much.
You're muted, Holly.
Okay, thank you. Thanks, Juliana. Some great work coming up. With that, I'll close our webinar. A really big thank you to all of our speakers for sharing their experience with us, and to all of you for participating. Clearly, enforcement cooperation is an important aspect of today's unilateral conduct cases. There are many approaches, frameworks, and supports in place to facilitate it, but there's also challenges and room to improve and explore new opportunities for more and better cooperation. So thanks, everyone. And thank you to the Autorité de la Concurrence.
Thank you. Thank you to the panelists.
Thank you. Bye-bye.
To the audience. Thank you very much. Bye-bye.
Bye, everyone.
Bye-bye.